amount lying in that GPF account, simple interest, my lord. Because 3 lakhs, my lord.
But whatever is blocked, whatever is transferred and what is blocked, that money would be made. Directions will. Now our directions cover it.
What they are saying in this, Lord.
Interest. No, we are not granting interest.
Look, what they are saying, Lord, they have got the benefit of the NPS investment, Lord, that NPS. They have not. They have.
I think we've drawn a balance. No interest.
I'm so great.
What remains?
Sorry.
What remains is just one small matter. That note and then you're not.
Yeah, please.
Is this
That is serial number.
third matter in my note?
Third matter in the same.
Wait. Request, Lord.
Yeah, please.
Have any implications on the other issues? So this
is nothing. There's nothing to do with
that.
Subject to
The larger pension issue.
that we've already said. We have already said that this is not all over here. We have clarified that so that nothing said here will have a bearing on the pension. That is very clear. We have said that.
Could that be reiterated that this?
That before lunch, so that I think you're protected. That's why I deliberately dictated that part separately.
Your Lordships kindly have page 6.
Page 6 for first note card.
These are not. This is a judge bullets.
Which one?
Of the Allahabad High Court, Mr. Jagdish. He was page 6 of
2021.
High bullets 1262 of 21. Would your Lordship 19 of my note bullets?
Yeah.
New pension scheme, because this was a judge even as a district judicial officer scheme. The third writ petition has been filed by a retired judge of the High Court of Allahabad. It is writ of mandamus of Article 32 of the Constitution of India, directing the pension to the petitioner appointed under Article 217(2)(a) B the Constitution of India right from the beginning. That's from 27. Well, three facts are important, and then show the act. The petitioner advocate for about 14 years and 8 months before he joined the Uttar Pradesh Higher District and Sessions Judge on 8/9. Thereafter, he was elevated as a permanent judge of the High Court on 22nd after serving 6 months. After serving for 6 years, 5 months, judge, he retired on 2002. The Office of the Accountant General issued payment pension 19/7/2018, determining the lesser rate than those judges who were eligible. Well, as the operative full years, 6 years. Would your Lordships now kindly, which is part of this very compilation,
Yes.
is concerned. Section 14, my lords, at page 14 of this compilation. Subject to the provisions of this Act, every judge shall be paid a pension in accordance with the scale and of the first schedule, provided that no such pension shall be payable to a judge completed not less of service for pension, or he has attained the age of 62 years, or his retirement is medically certified by Hillel. The emphasis on clause A, my lords, as he has completed not less than 12 years. Provided further that if a judge at the time of receipt of a pension, other than a disability or wound pension in respect of any previous service in the union or state, and not in addition to that pension. In this section, judge means a judge who has not held a pensionable post under the union or a state. Includes a judge who, having held any post under the union or state, has elected to receive pension payable under Part 1. Period of 10 years. 10 years shall be deemed to have been added from 1st April to for the purposes of pension of a judge who is a judge under subclause clause 2 of 217 of the Constitution. Bar millets. C15. respective judges who are every held any other pension or a state shall on his pension in accordance with the first schedule, provided that who is elected to receive either under part 1 and the pensionable payable to him shall be B. That's at page 22. In this case, my lords, there is no doubt he was on part 3, page 22. So this part should apply held any pensionable post who is not elected to payable under part 1. The judge shall be which he is entitled not been appointed a judge. His service as a judge service therein for the pension and a special rupees so and so completed service for pension. Proviso is important, my lord. Provided that the pension under clause A, pension under clause B shall in no case 15 lakh per annum justice, lakh 50,000 per of any other judge. At best, my lords, a judge justice is entitled of rupees 13 lakh. See, pay. I thought it's easier instead of taking your lordship to the paper book. Pension order. 5 minutes.
Yes.
Fixed at 1,77,035. Your lordship saw that.
1,07,735.
Sorry, 1,07,735 minutes. This figure has been arrived using part 3. What the state has done? It has calculated the pension you would have been in district judge plus added to it B additional pension of rupees 45,000 of each year of completed service. That per annum for each year of completed service, my lords, is calculated as 6 years because he has served 6 years, 5 months. So each year of completed service, at best, he gets 6 years because he was in the. Now I read your lordship's 14A, where for judges from the bar, even if they worked for 4 years or 5 years, 10 years is added introduction of 14A because they get that 10 years additional benefit. So the moment they complete 14 years, they touch the upper limit of 13,50,000. I hope.
For members of the bar.
For members of the bar. Unfortunately, for the district judge, although he has served more than 18-20 years, the only benefit that is counted for the district judges, those completed in the High Court. For members of the bar, there is an addition from their practice, but what is discounted for the district judge as a district judge. I hope your lordship that the
Yes.
discrimination is
There's no addition made to our district judge.
that 10. So what happens is a district judge who puts in 6 years, 7 years service also will never make it to the 13,50,000 upper bracket, which is the maximum pension that a High Court judge can receive under. This argument is flawed. This reading is flawed because if your lordship kindly see 217 for a minute. Article 217.
So how have they calculated this pension? You said that 1,07,735.
His normal pension that would have been entitled to if he had continued as a district judge, and that special pension is only added for 6 years because he has completed only 6 years. He should have been actually entitled to the full benefit of those 10 years.
Pension is added under that section.
Under that
Under
section.
part 3.
That's right. So, if he has completed, if he gets the maximum, that is 13,50,000, which is permitted under part 3, the judge would have been 1,12,500 instead of 1,07,735, because he is not able to get the maximum benefit because completed years of service under Part 3 is only counted
It
as
doesn't get addition of 10
the
years.
addition of 10. But should kindly see 217 clause 2. Constitutionally, he ought to have served as 10 years minimum a judge for appointment as a High Court judge.
10 years head judicial office.
As a judicial officer. So the Constitution itself presupposes that for a judicial officer to be elevated as a being minimum 10 years service.
Fees per month is what they take. Then they deduct his commutation, which is 6,200.
That's right, Mullah.
So 1,01,000.
That's right, Mullah. But he doesn't get full pension of 1,000 because
So it would collapse.
no, Mullah, he will only get 13,50,000 divided by 12, which is 1,12,500
Per month.
per month. Instead of 1,07,735,
Right.
full pension they will get 1,12,000, right? So
I don't know the exact pension.
calculation because 13,000, 1 lakh.
Okay. Thousand is 1 per month.
1,12,500 per month.
Right.
Full maximum. It's a maximum. Under Part 3, 13,50,000 is the upper cap. Their argument is we are unable to reach the upper cap because, like in many of the judges elevated from the bar, might not get the entirety of
So he lost about 5,000 rupees per month.
5,000. But on commutation family pension, it has ripple effects. It has ripple effects. The point is the Constitution itself says that to be appointed from the district judiciary to the 10 years minimum service. So if you can count 10 years of service from the 10 years of practice from the bar under in terms of section 14A, because 14A did not come just like that. 14A came as a consequence of Ramakrishnam Raju, para 24. 14A was introduced pursuant to your lordship judgment in Ramakrishnam Raju, where your lordships, even without a statutory provision, said you cannot put judges who are elevated from the bar at a disadvantage, and your lordships must, and the state must count the 10 years of service, 10 years of practice from the bar, fixation of their pensionary benefits.
So what you are saying is that count 10 years for the purpose of computing the special pension in Part 3, that a special additional pension of 45,000 per annum in respect of each completed year of service for pension.
That's right.
You must add the 10 years there because they rank at par.
They rank at par, and that's a constitutional mandate. It's not just a statutory mandate. It's not as if, so far as the lawyers are concerned, your lordship by interpretation said that 10 years must be counted. This actually 10 years at least. In this case, 18 years as a district judge. So, AC.
Respectfully,
Not applied to mind to this case, but then these are fortuitous circumstances. In every case,
No, no.
you will have a grant of benefit like this, and
I'm
it becomes an endless
but-
calculation.
If my little, just bear me for a minute. I'm simply saying, Lord, give me the benefit of your lordship judgment in Raju, where squarely identical acts have been considered, and your lordships have laid down. Just give me that benefit. Kindly have that judgment, my lord.
but did Raju say that you must add 10 years for the service judges also?
Not Raju. Your lordship judgment is Raj Rao, which
That's right. That we place them at par.
your lordship they take.
There's a break. Apply Part 3, that is one which I'm saying, but the other thing I'm saying is that at least because our judicial service, a lawyer can directly be recruited if he has
That's correct.
been a lawyer for 7 years. Yes. Para 23, 27 and 30, 31.
30. That is really covers the issue.
Your Lordships have already noted that judgment of Raju's Ground, Your Lordships 10 years
And we followed Ramkrishnam
Your
Raju.
Lordship followed that, and in 27, the Lordship said that the
Question
post-retirement
14A a little bit, because 14A was intended to give the benefit to people who,
Yes.
and these are people who also put in 10 years of service.
Not only 10 years of service before being recruited in the HJS, we've been a lawyer for 14 years. So 7 years I have to qualify for being a HJS. 3 is applied, and that is years given others, which is, and your Lordships have given already. So just apply this judgment to me.
Instead of the service of the bar, I would say that it's 217 too, because constitutionally the constitution says that 10 years. If that benefit is given, they all reach
So
the max.
this amount, this particular figure has been fixed, last paid drawn as a district judge.
That's right.
And not as a high court judge.
That's right.
If you apply 14A, this para 30 straightway applies.
Yes.
So the last pay drop as a district judge.
That
Yes.
plus the special additional pension of
Correct.
45,000 is capped for every year of completed service as a high court judge.
Right.
So for them, 45 is multiplied only by 6. If 45 is actually multiplied by 10, the moment they also finished 4 or 5 years of service, as,
Cap the
they-
minimum thing at 13 lakh per 50,000.
13 lakh 50. At any event below, it can't go below 13 lakh 50,000.
Yes.
So it's not really, it's a difference of 5,000 rupees. Person passed away, right?
No, he's in the life, he's for now.
Yeah, in case which we
Earlier,
She was a patient that she was in diabetes.
this person is 84.
84
He
now.
retired in 2000. So he will get that additional benefit from the date of his retirement. He'll get a substantial amount,
Full pension and
5,000 rupees more.
so if this
Additional pension.
I'm not sure about. He'll get full pension.
Mr.
I have not really applied my mind to this case, but I thought we are trying to add too many things in a statute, and the statute will be virtually rewritten.
He's put in.
Virtually, I have to be rewritten like.
No, but he has put in 10 years of service as a judicial officer, because otherwise he can't be appointed as a judge of the High Court.
That's true.
Same thing as in the case of a lawyer, right?
No, but then a lawyer
10
case,
years
you will
as
always
judicial
came to the
officer
rescue
and
of a
10 years
lawyer.
as an advocate.
Coming to the rescue of a member of the bar is in different parameters. Because you have a lesser number of years of service, add a certain quantum so that you get
There's
a
already a judge.
pension. But to say that in every case
There's
of
already a
a
judge.
district judge to give this benefit of a notional quantum of service.
This para 30. We'll try to persuade you.
Because after all, they have the benefits. I'm sorry.
Para 30.
That's right. in 14A.
But that will not be subject to the question as to the actual service they would put in.
Now read 14 capital A.
Yeah.
These are the rules. Statutory rules.
A period of 10 years shall be added and be deemed to have been added.
Deemed to have been. And it says, who is appointed as such judge under subclause B of clause
The
2
bracket.
of article 2.
217 2B. Please hand it over. So it is for 217 2B you will get the benefit of the not for any other class.
Not falling within category B, Mr. Dwivedi?
She was not. She was also a member of the district judiciary. Mallas.
I
You
mean,
are?
absolutely.
She was also a member of the district judiciary.
Because he had put in.
Because what happened, Mallas, there are 3 sets. She was also a member of the. Look, there were 3 sets of judgments.
Paragraph 3 says,
The Lordship judgment.
appointed as judicial magistrate and then the additional district judge.
2021. The British now. Yeah.
They're not dealing with the question of there would be a future question of parity, etc. in other services.
No, we are governed by a statute here. It's a separate statute only for High Court judges. There's no other. There's a specific statute only for High Court judges. The Act of 1954. That's why this will not.
The losses may
That's why
suitably clarify, Lord.
We have said we are not dealing with a new pension scheme at all. That we are not dealing with. The petitioner practiced as an advocate for about 14 years and 8 months before joining the Uttar Pradesh Higher Judicial Service and Sessions Judge on 8 September 1977. Stop. He was elevated as a permanent judge of the High Court of Judicature at Allahabad on 22 March 1996 after serving in the district judiciary for 18 years and 6 months. Stop. He attained the age of superannuation as a judge of the High Court on 26 August 2002. 2002. After 6 years, 5 months and 5 days as a judge of the High Court. Full stop. A pension payment order was issued by the Office of the Accountant General into brackets A and E bracket dash Roman 2 UP Allahabad, which his pensionary payments were computed. Next, the grievance of the petitioner is that his pensionary payments, that is pension computed at a rate lower than those judges who were elevated from the bar. Next. Pension payment order dated 13 July 2018 contains the following tabulation. Item number 5 to page 28 को in note 1 page 28 को मैंने mark कर दिया. Part 3 full stop. Section 15 of the High Court Judges bracket Salaries and Conditions of Service bracket Complete Act 1954. Footnote देखे Act number 28 contains a special provision for the grant of pension to judges who are members of a service. Section 15 is in the following terms. Here page 15 को copy कर लीजिए. 15(1). Part full stop. The petitioner elected for pensionary payments. He elected under Part 3, right? Under Part 3 of the first schedule, which is set out below. ये page 22 को Part 3 copy कर लीजिए. In terms of the above, full stop. In terms of clause 2 of Part 3, the petitioner has to be paid A, the pension to which he would be entitled under the rules of service if he was not appointed by the court. Semicolon and bracket B, a special additional pension of rupees 45,016 per annum in respect of each completed year of service for pension. Section 14A of the of Act 28 of 1954 contains provides for the addition of 10 years of service of 10 years with effect from 1 April 2004 for the purpose of pension to the service of a judge who is appointed as a judge of the High Court under Article 217, bracket 2, bracket B. So, Article 217, bracket 2, bracket B, bracket 2, bracket A provides for, Article 2 provides for the qualifications for appointment of as a judge of the High Court. Full stops. Clause provides for the appointment held judicial office for a period of at least 10 years, while Clause B provides an advocate who has been an advocate of a High Court for at least. Full stop. Section 14A has provided for an addition of a period of 10 years for the purpose of pension to persons who fall under Article 270. Full stop. The issue is as to whether the petitioner would be entitled to the addition of a similar benefit. Full stop. In this context, it would be necessary to refer to the judgment of this court in versus Justice Retired 24 INSC 219, where it was held thus. 30 copy कर दीजिए वो judgment का. Stop. That apart, it is evident that the petition as a judge of the High Court, since he had held office, since he had held judicial for at least 10 years within the meaning of Article 2A. Stop. However, he was also a member of the bar for over 18 years and 6 months, right? 14 years and 8 months prior to his appointment as a judge of the High Court. Backdrop, you are of the view that it would be appropriate, particularly having regard to the stated in the above decision, to direct that the pensionary be recomputed benefit of an addition of 10 years of service on grounds to those on 10 years of service, clarified that the maximum pension which is payable of rupees 13,50,000 per annum shall continue to stop. The petitioner retired from service on 26 August 2002. Stop. The difference in pension, the difference in pensionary payments payable to the petitioner that effect from the date of his retirement within a period of 3 months, and the arrears that are due and payable in terms of the present order shall be paid over within a period of no later than, we say, 2025.
Will every case of a district judge who has less than, they will have the benefit of service.
Look at
Because this will certainly lead to
all of these people, the services members of
that
all directly
large
district judges have.
takes care of. Therefore, you are eligible to appoint. Therefore, to say
That
go back to a member of the bar. Therefore, unless that
qualification.
anything which is as far as the High Court, this will lead to that. Every judge who has even a 2-year service will say, I'm entitled to.
Members of the bar, why not? They spend their whole life. You know, a lawyer does at 56.
Something good.
You know,
High Court.
a lawyer who comes in,
but
then why not? Who becomes a judge for? They don't come at 2 years of service because it should be at least 50. They must.
these are the appointment process. Therefore, how do we this question? Will invariably this rule will apply. It will apply then.
Put in 10 years.
No.
We have the judicial officer. Before he had put in 10 years.
Not debating with the law.
In the parity of 14A.
Whether
he didn't come in as a member of the bar.
That would require some legislative amendment to say that. That's why I'm raising. Then, unless your lordship say this will not generally apply, then one has to. Then the parliament will have.
Answered in Ramakrishnam Raju clearly 10 years back in 2014.
Right.
May I read this?
Raju,
Who occupied the constitutional office of judge, High Court, retired. Any discrimination with regard to their pension, irrespective of the source from where the judges are drawn, must be paid the same pension. They have been paid same salaries and allowances and.
Ramakrishna Raju was necessary in order to bridge the gap. Did not have the benefit of pension. Therefore, lordships made all the observations when travelled all the distance. But to say that in the case, same logic. In the case of every district judge, you are even a minimum of 2 to 3 years of service. Please, that's an important question to be somewhere bracketed.
The continuous assertion of the fact that there are 2 classes of High Court judges.
I see.
I tell you what weighed with us. Though not drawn from the bar, his eligibility is not, or qualification is not as a member of the bar. But what 14A does is, who are drawn from the bar, it allows for an addition of 10 years.
For good reasons.
Right.
For good reasons.
Right. Now, a district judiciary who had at least 10 years of service as a member of the appointment as a district, appointed, the direct recruits have. In that case, what is the the benefit of 14?
We asked us to ponder over that question because it may have serious implications. Because this,
What serious?
if it is left unqualified, that could be a problem.
Judges are serving
Left unqualified, that could be an issue.
Assertion that there are 2 classes.
No.
Every argument is a continuous assertion of High Court judges.
6 months and higher, especially plus 6 years as high income.
To be either you'll also clarify that. Otherwise, I think it needs to be dealt with. I have a problem there.
We'll just tighten it up, yes.
I'm sure lots will do that. Because not for without reason, I'm advancing this.
As an aside, Justice Kailasnath Panchu has 2 distinctions, Minots, in the history. Continuous service from 1927 as a magistrate all the way up to the Chief Justice of India. a distinction no other Chief Justice of India has had. Two, he's the only Chief Justice of this country, my lords, who never was an ICS officer. So I'm saying we've had brilliant judges, the district judiciary who have served this court, my lords. So this constant assertion that there are conditions must apply from the district judiciary and I think that we've had brilliant judges. I mean, I said I because of the unique.
So weren't you the only ICS judge, or there was
Chief Justice.
as the Chief Judge? There were others as well.
Chief Justice.
As Chief Justice.
Justice.
As Chief Justice. Justice Pal, rather than Pal was also.
Justice is the only Chief Justice without a law degree.
Of Mr. S.V. Raju was a judge in Gujarat High Court. He was an ICS.
Yes, is it?
Justice V.B. Raju. Yes.
V.B. Raju, yes.
Yes.
Who wrote that famous book on V.B. Raju?
Wait for us.
It's item 24 will have to be deferred post decision on the NPS scheme because that's will call out that and the other connected matters where your lordship will have to first take a call on the pension scheme.
On
And
that.
then
25 now?
I this was almost covered by Russian judgment round then.
it's under the new pension scheme because I'm sure the Learned Attorney General will have there'll be something to say about this and this will have impact on the scheme.
We have at least resolved this.
Please also this judge.
25?
Plus 25 is the
15,000 pension, my lord. You just said. And yes,
24 is All India Judges
That's
Association.
all.
25 is All India Judges, my lords.
Ajit Singh, my lord.
Justice
Ajit Singh.
Ajit Singh, my lords, is a judge who was born under the new pension scheme so far as the district judiciary is concerned.
That may have to be argued.
That's what I'm trying to ask.
My lord, Fulvan decided in 7.5 and from 1st April
Let
2005.
us do something apart from our own pension matters. We must do some other work as well. So we'll take it some other day.
You will be meant to go to one late.
I think so.
My lord, with your permission.
Even the amicus curiae is saying that.
I think they should fairly wait the decision.
5 minutes, my
All right, we'll take it some other day.
tomorrow, my lord. Then. Some other day is tomorrow.
Too many.
The state of anxiety, my lord. Everybody is.
Too many red flags.
We are all subservient to the constitution.
Always Rahul last judgment, man.
That is to be done. That's part of life.
Your permission, my lord.
But this involves a new pension scheme.
Either issue. So many implications are there, and then the changes in the pension scheme.
Although it's a High Court judge, this has definite impact. That's why I be taken up after the new pension scheme is decided in item 25.
Well, it is, yes, 25. No?
That's the
My lord, with your permission, my lord.
Let me follow.
I have filed an MA for a single person who is seeking pensionary benefit.
You can't file. You file your.
Lordship issued notice, and this is a.
How can we deal with an MA in?
It is listed today, my lord.
But you file your own proceeding.
No, your lordship
File his own proceeding.
in your lordship's last order, your lordship said wherever individual judges have concerns, my lords, it must go back to the committees. Your lordship said.
No, that has been decided, and therefore your lordship's
No, no,
issued notice.
No, I'm
For
saying
one
the
forward.
MAs will keep coming. IAs and MAs will keep coming, my lords.
All right, yeah, 26.
Well, it's 26 are my applications. I'm the secretary of the Delhi Cricket Association.
I think
Lordship, there's a report.
26 are the IAs. There are 2 IAs which are listed. On behalf, just 1 minute, which are on behalf of the secretary of the association.
Lordship, there's
Now-
a report by the amicus in this matter, my lord. Earlier amicus.
In any, I just
There
state
is a
what.
report on this, but I just
No.
want the price.
contesting respondents are represented by Mr. Ranjit.
Keep it some.
Your lordship may have it tomorrow, my lord.
There's a small issue.
take
Yes,
it up.
yes.
Sorry.
My lord may also list, my lord may also list the BCI. It's just for approval. Yeah, Micah's my lord.
I'll-
The Bihar Cricket Association.
Any of the
Take it
states,
up.
When, my lord, there is a small issue. If this is, my lord, regarding the coastal road in Bombay,
Yes, yes.
my lord, there was which I made that let us road build. We will not do anything with regard to, my lord, the outer side, my lord, etc. My lord, where now, my lord, we have, my lord, someone doing it free of cost, my lord. The what do they call
What-
land?
The application, can you show us the
Yeah,
exact
yes, my lord, kindly have a look at, my lord, 2-4.
कौन से page पे है, right? Additional?
Look, the road is almost complete. Almost means 96% the coastal road is complete. Only thing which is required is, my lord, on the sides, landscaping, my lord. Sides and the middle, my lord, in the road. And we have, my lord, a voluntary agency, my lord, which is doing it.
3315, no?
Yes, but double, tell him, I'm sorry. 5-1, my apologies. 6%.
I'm just briefing.
Median landscaping work and permit the
The
volume.
voluntary agency, my lord, have, my lord, contacted us that they are ready to do it free, my lord, with their logo. That's all. The road,
For the other side?
I'm not aware, my lord, but we have served the other side, my lord, at the time of filing, quite. But
Some of the respondents, it's supposed to be that side, but they are extending.
And permit them to come carry out the landscaping work?
Need to file a reply to this thing.
Not necessarily this. Number 242151 of 2024. The IA has been filed by the Municipal Corporation of Greater Mumbai.
yes,
Order of this court dated 30 September 2, the certain conditions were imposed, including the following. That is clause 2, right?
yes.
Para 9 में आए के clause 2 copy कर लीजिए. It has been stated that in pursuance of the above order, a total length of 9.83 kilometers out of the total 10.58 kilometers is completed. Stop. The municipal corporation desires to carry out the work of median MEDIAN landscaping, permitting the agency appointed by it to display its logo and corporate messages at appropriate places in terms of its policy dated 11 October 2024. Stop. The permission is accordingly granted. Orders as may be passed in these
Yes.
proceedings.
Grateful, my lord. But I am told, my lord, your lordships are to rise.
To,
May mention, my lord, 22 and 45. This is that
yes,
where, my lord, we are completely without any protection, and the award is
1,764
yes, my
crores.
lord, 1700. Can it be tomorrow?
Can it be day after? That's all I'm requesting. Tomorrow there's some difficulty. Day after it's fine.
Okay, we'll take it up day after first on board. We'll
Yes, very
It is possible.
no difficulty.
27.
28.
22 and 45, they are cognate.
Yes, yeah.
Public.
Is RG Kaur also there today on board?
Yeah, RG Kaur is on board, my lords. Can it be?
I think what we'll do is first on board tomorrow. We'll take it still number 1 on board tomorrow. Because today we have to rise. There's a function
Yes, your lordship.
of the event
Reach
day
the-
for which we have Rashtrapati Bhavan. Now, what about the rest of the matters? 20?
Item 28, there's one SLP already here. The other one is the SLP criminal 50109 of, if you can have it taken together.
That's Sanjay Kundu matter.
There's the connected diary number 50109 of 24 against Team Judgment. I am a senior advocate who is also subject matter there.
Oh, he's that senior advocate who is there. All right.
That one. So if both can be taken together.
Then item 27, Lord, I'm sorry, item 27 was called out. I was running here and it was impossible to get here in time. Item 27, something very serious objection. What after filing an based on some previous which was there on while their own application they 11th of October and based on that application saying give us the as per the new directive we need to file a directive.
They want to carry out some media.
30-year first come first serve 15 years corporate 15 years for private concessionaire. One was a temporary thing. It was 6 months at a time, not more than 3 years. Open bidding or anything. First come, first serve. 30. That entire they filed it. They filed this on 15th October.
What we will do is,
So please allow us.
what we'll do is we'll permit them in principle to carry out landscaping.
The whole thing is to give it to private parties. They are not doing it themselves.
We are
Free of charge.
No, kindly keep it tomorrow, my lord. I'll explain.
1 second. Mr.
Yes.
Singh. It's landscaping work with the municipal
It's
corporation.
with advertising.
What we will say is that we are not authorizing them to appoint any particular agency. The legality of that will be decided.
No, it becomes a fair company. 11th, we are today, Lord, on the 5th of November. 11th October, during the pendency of their application based on a policy which has been there for 20 years, they had applied in September to your lordships based on the old policy. During that pendency, 11th October, they issue what is your lordship. Please just see that. Now, let me just tell your lordships.
1 second.
Just give me a moment, Lord. Give me a moment. Yes.
I see your problem that they should contract to a private agency, right?
No,
You can't have an objection to landscaping.
no, our objection is to that development that there's a judgment in our favor. This is an interim order. Your lordships have stayed the judgment, allowed them to.
Well, somebody wants to carry out, but
They're not doing it themselves. Please just see that policy.
well, we are not authorizing them
No,
to
but
find some other agency.
the application is only for that. The application is specifically as per our policy of 11.
Therefore, if you clarify.
Look, what I asked myself this question, that if on 11th October they frame a new policy, 15th October they apply to your lordships, today is the first day of that application comes up without notice to us, without opportunity to file a reply, your lordships are passing an order and that order is only for that policy, 30 years.
Because the land
It's
cannot
not-
harm environment.
It's not, it is harming because it is making that entire thing permanent. There is a judgment in our favor saying this can't be done. They have not taken environment clearances.
Mr. Singh, you also belong to Mumbai and I've just used
I'm only on this. Lordships never pass orders without giving notice.
Under the sea is there now.
Your lordships never pass orders without giving notice to I'm the successful party. There's a judgment in my favor. Your lordships have not set aside that judgment. Your lordships have allowed them to do some things in the interregnum.
All right, we'll keep
So
it.
keep it tomorrow.
All right, we'll keep it tomorrow.
Yes,
Then,
yes.
Item
Deeply obliged.
4 is that international commercial arbitration.
Just give us a short note on who you are appointing. Otherwise, what we'll do is we will give you.
It says first come, first serve.
Only a
Boss, 30 years.
Mr. Solicitor, you take instructions, you invite tenders for the award of the contract, and then take a decision.
No, the difficulty is tender would mean whoever bids the lowest or highest.
Oh.
Free of cost. They are doing
Free of
Completely free of
Advertising. The person is going to get money with advertising on that thing. The third party rights are get created.
Main litigation about.
The main litigation is
Just a minute.
yes.
It has something to do with legality, validity of the environmental clearance. Right?
Not just the environmental
Just-
clearance, also.
Have some patience.
Yes, Manoj, I'm sorry.
High Court said that we are not permitting you to go ahead with this project of making this road.
That's right, the coastal road.
You have to obtain some permission from this authority, that authority. Okay.
That's right, yes.
By way of some interim orders passed by this court, we go ahead with the road.
Only to secure the. Yes, yes.
Please.
My lords.
Now, a statement is being made that 96% of the road is completed.
That's
Correct?
right.
Okay.
Under interim orders of your lordships.
Doesn't matter. It's our order.
My lord.
It's
Yes.
our order.
Yes, yes, of course.
Now, if that is completed, they want to do some landscaping. If the issue is about who has to do, how it is to be done, whether bids are to be invited or not, litigation, as petitioner, you can't raise. Who will not do it? Conditions it will be. Doesn't
And
matter.
your lord,
We will.
because I don't see has ever lords passed orders allowing the party to be heard.
sauntered into the court. Where were you when the matter?
No
You can also
notice.
say that you are not here.
I'm sorry. I was running. I got, there was a
We
big
can
crowd
pass an
outside.
You. Fair enough. We'll keep an ad interim order. Tomorrow we'll pass.
Your lordship, sir, your lordships are keeping.
Let him say how this harms the environment. Locus is only if there is a and somebody is
Tomorrow.
doing it.
Yes, all right.
Fine,
Tomorrow
right,
we'll
later.
see now.
How do I
Mr.
decide?
Solicitor, somebody else now.
44 is that arbitration. Realistically speaking,
We'll
it
be able
won't
to
be
take it
possible,
up.
my lord. Your lordship. No, not tomorrow, day after. Have it next week, my lords.
We'll keep it after.
Very good.
We won't end the matter because
Yes, my lord.
take a couple of hours at least to complete the matter.
Very great.
Item 31.
With my lord permission, 30.
Lordships had heard us on the disability.
Yes.
Of those candidates who
Yes.
took part in the judicial service.
My lords,
We have filed a
yes.
special for-
I have also filed.
So Lordships can just give us 10 minutes tomorrow minutes because pursuant to your law, two
All
persons
right.
were actually selected.
All right.
That
We'll,
those minutes what we were.
Fair enough.
Give us 10 minutes.
because it has blind candidates for the judicial.
Because the 41 is connected, my lords, to this matter.
All right. We'll
Item number 30.
matter, that disability matter,
Yes,
is to argue it, so we have uploaded the judgment.
That I've seen, my lords. Your
Tomorrow.
Was item
Vidarbha, because item 4. Will be kept tomorrow because one of the matters has to be withdrawn and one will take 10 minutes.
Should we record that you are withdrawing it right now?
We'll do it tomorrow when both are.
I am here.
You want to engage a senior Mr. Mahesh after for withdrawing the matter?
My lord permission, my lord.
Yeah, I mean, not neither.
Lords,
You are the other side.
item 30, my lord.
But I am here, my lords, in item 4.
Item 31 is where would your item 30, my lord. Item 30 is a sanitary pad matter, my lord. Item 30, my lord.
The matter where Professor Danda has made the report.
Who?
Professor Danda?
Danda.
Yes.
That Rajiv Raturi, that
Yes.
disability report.
Yes.
Yeah, we have to hear that.
And the written.
My lord, item 30 is also.
We also filed for the government. We've seen those written submissions.
My lord, item 30, my lord, is
Tomorrow because
My
it has to
lords,
be.
may I just-
Last time Dr. Amita from Nalsar, right? She was here on the screen last. I also like to hear Dr.
31 as well, would your lordships have it tomorrow, my lords? That's the arbitration petition. There's a divergence of views between high courts when
There's no divergence in arbitration clause.
Oh, that provides for the
Bogota.
Bogota.
That's correct.
That's matter.
Dismiss is not maintainable also.
And there is
I agree.
conflicting.
Let's please have it tomorrow and please send it to me.
One way or the other, because specific exclusive jurisdiction clause.
It's not matter, but we'll give you a hearing tomorrow.
I have no difficulty.
Lords, the reason being, my lords, what that the exclusive jurisdiction clause decides the seat of arbitration.
Let's part
and
one
not
has
the
to apply
place,
in the
not the
place.
place.
How does that come?
Thursday, we are pronouncing a judgment on this. Either of the
I think-
side will be governed by it.
Lordships have it next week or next
As your
Item 5